Hello, I'm SA, your AI essayist. Please note that all content, audio and video in this presentation are AI generated. As AI can sometimes produce inaccuracies, I encourage you to verify any factual information presented. With that in mind, let's begin.
The late 9th century in America presented a landscape dramatically reshaped by industrial expansion. Across the nation, vast fortunes were amassed, and enterprises of unprecedented scale emerged, fundamentally altering the economic and social fabric. This era, often characterized by its dazzling displays of wealth and technological advancement, also harbored deep currents of inequality and exploitation. Powerful industrial combinations, known as trusts, consolidated control over key sectors of the economy, wielding immense influence and often engaging in practices that stifled competition and disadvantaged smaller businesses and individual consumers. The very mechanisms of progress, it seemed, were concentrating power in fewer and fewer hands, creating a societal imbalance that demanded a discerning and forceful response. Within this dynamic and often turbulent environment, a young lawyer named Louis Brandeis began to forge a path that would distinguish him as a singular voice for public interest. Arriving in Boston in the 870s, Brandeis entered a legal profession deeply intertwined with the burgeoning economic powers of the age. Yet, from his earliest professional endeavors, his approach diverged from the conventional. He did not merely seek to represent clients within the existing legal framework. He aimed to understand and, where necessary, reshape the framework to serve a broader conception of justice and the common good. His early career was marked by a profound commitment to public service and intellectual curiosity that drove him to dissect complex economic issues and a developing conviction that the law should be an instrument for fostering a more equitable and efficient society. The challenges Brandeis encountered in his initial years were emblematic of the era's systemic issues. He witnessed firsthand the monopolistic tendencies of powerful corporations, their ability to dictate terms to consumers, and the often limited recourse available to those adversely affected. The legal battles of the time frequently revolved around property rights and contractual obligations, but Brandeis increasingly saw these as intertwined with larger questions of economic fairness and the public welfare. He recognized that the concentration of economic power was not simply a matter of business strategy. It had profound implications for democratic governance and the opportunities available to ordinary citizens. The prevailing legal interpretations, he perceived, often favored the established order, inadvertently reinforcing the dominance of large trusts and obscuring the detrimental effects of their unchecked power. Brandeis' response to these challenges was to cultivate a distinctive style of legal advocacy, one that was as much about intellectual inquiry as it was about courtroom argumentation. He approached each case with an intention to understand the underlying economic realities, the historical context of the industry, and the broader societal implications of the legal questions at hand. This analytical rigor, coupled with an unwavering dedication to the public interest, began to earn him a reputation as an exceptionally capable and principled attorney. He became known as a lawyer who would take on cases that others shied away from, particularly those involving significant public stakes or challenging powerful vested interests. This positioning as an advocate for the common good, a people's lawyer as some might later describe him, was not a calculated political maneuver but an organic outgrowth of his deeply held beliefs about the purpose of law and the responsibilities of those who practice it. His early legal work involved navigating the complex regulatory landscape of the time, which was still nascent in its attempts to grapple with the consequences of industrial consolidation. Brandeis delved into the intricacies of railroad regulation, utility monopolies, and the burgeoning insurance industry, seeking to identify legal avenues for promoting fairness and efficiency. He understood that effective legal solutions required a deep grasp of the economic principles at play, a commitment to empirical evidence, and a willingness to innovate in legal strategy. This intellectual foundation would prove crucial as he began to formulate more comprehensive critiques of concentrated economic power and to advocate for systemic reforms. His early successes, though perhaps less widely publicized than his later achievements, laid the groundwork for a career dedicated to challenging the status quo and advocating for a more democratically structured economy. The seeds of his later arguments against excessive corporate size and his vision for a competitive marketplace were sown in these formative years, shaped by the pressing realities of late 19th century American capitalism. The enduring tension between corporate power and the public interest, a central theme of his life's work, was already a palpable force in the legal and economic arenas he navigated. Through these early triumphs, Brandeis cultivated a profound understanding of the interplay between law and economic reality. He recognized that the legal framework of his era often lagged behind the rapidly evolving industrial landscape, creating opportunities for exploitation and inefficiency. His keen intellect, honed by rigorous legal practice and a deep engagement with economic theory, began to coalesce into a distinctive philosophy that would challenge prevailing notions of corporate power and market organization. The late 19th and early 20th centuries witnessed an unprecedented concentration of wealth and industrial control in the United States, a phenomenon that Brandeis viewed with growing concern. He perceived the rise of trusts and monopolies not merely as economic arrangements, but as fundamental threats to the principles of a free and democratic society. The problems of this era were stark. Large industrial combinations, often formed through mergers and acquisitions, exerted immense influence over their respective markets. This concentration of power frequently led to practices that stifled competition, suppressed innovation, and resulted in inflated prices for consumers. Workers, too, bore the brunt of this unchecked corporate might, facing meager wages, unsafe working conditions, and limited bargaining power. Brandeis observed that the legal system, often deferential to established economic power, struggled to provide effective remedies for these systemic injustices. Existing antitrust statutes, while present, were frequently interpreted in ways that allowed these vast economic empires to flourish, prioritizing the abstract concept of contract freedom over the tangible impact on public well-being. Brandeis's unique solution emerged from his conviction that the law must be a dynamic instrument responsive to the evolving social and economic conditions it governs. He articulated a powerful critique of what he termed bigness for bigness' sake. This was a rejection of the notion that sheer size and market dominance were inherently beneficial or indicative of efficiency. Instead, he argued that beyond a certain optimal scale, large organizations tended to become bureaucratic, inefficient, and prone to abuses of power. His vision was one of a decentralized, competitive economy where opportunity was broadly distributed and where individual initiative and small and medium-sized enterprises could thrive. This was not a romanticized call for a return to agrarian simplicity, but a pragmatic argument for an economic structure that fostered genuine competition, encouraged innovation through diverse players, and prevented the undue concentration of economic and political influence. He championed the idea of fair competition as the bedrock of a healthy economy. For Brandeis, fair competition meant a marketplace where businesses competed on the merits of their products and services rather than through monopolistic practices, predatory pricing, or undue political influence. He believed that such a system would not only benefit consumers through lower prices and higher quality goods, but would also foster a more dynamic and innovative industrial landscape. This required a proactive legal and regulatory approach, one that actively dismantled existing monopolies and prevented the formation of new ones. His advocacy extended to supporting policies that would empower workers, enabling them to organize and bargain collectively, thereby achieving a more equitable distribution of the economic gains generated by industry. His arguments against concentrated economic power were meticulously developed and supported by extensive research. He delved into the operational realities of large corporations, examining their management structures, their impact on labor relations, and their influence on political processes. He was a keen observer of the ways in which the legal and financial mechanisms of the time facilitated the growth of these industrial giants, often at the expense of broader societal interests. His writings and speeches from this period reveal a consistent theme: the need for the law to actively promote a more equitable distribution of economic power and opportunity. He saw the concentration of wealth and control as inimical to democratic ideals, arguing that an economy dominated by a few powerful entities could easily translate into an unhealthy concentration of political power, undermining the very foundations of representative government. Brandeis's approach was characterized by its pragmatism and its grounding in empirical observation. He was not content with abstract pronouncements about economic freedom. He sought to understand the concrete mechanisms through which economic power was wielded and the tangible consequences of its concentration. This led him to advocate for specific policy interventions. He was a strong proponent of robust antitrust enforcement, believing that the Sherman Antitrust Act and subsequent legislation should be wielded vigorously to break up monopolies and prevent anti-competitive practices. He also supported measures to increase transparency in corporate finance and to regulate the activities of financial intermediaries that played a crucial role in the consolidation of industries. His critique of bigness was also a defense of individual liberty and human dignity. He believed that a society dominated by large, impersonal corporations could lead to a sense of powerlessness among individuals, both as workers and as citizens. A competitive economic order, in contrast, offered greater scope for individual initiative, self-reliance, and participation in the democratic process. He envisioned a society where individuals had meaningful choices, both in the marketplace and in their civic lives, and where economic structures did not inherently limit those choices. This deeply held conviction informed his persistent efforts to shape public policy and legal interpretation in ways that would foster a more democratic and equitable economic order. The legacy of his arguments against unchecked corporate power and his vision for a competitive economy continues to resonate in contemporary debates about market concentration, regulation, and the balance between economic growth and social well-being. His intellectual framework provided a powerful challenge to the prevailing laissez-faire attitudes of his time, advocating for a more active and interventionist role for law and government in ensuring a fair and functional marketplace. The prevailing economic order, in contrast, offered greater scope for individual initiative, self-reliance, and participation in the democratic process. He envisioned a society where individuals had meaningful choices, both in the marketplace and in their civic lives, and where economic structures did not inherently limit those choices. This deeply held conviction informed his persistent efforts to shape public policy and legal interpretation in ways that would foster a more democratic and equitable economic order. The legacy of his arguments against unchecked corporate power and his vision for a competitive economy continues to resonate in contemporary debates about market concentration, regulation, and the balance between economic growth and social well-being. His intellectual framework provided a powerful challenge to the prevailing laissez-faire attitudes of his time, advocating for a more active and interventionist role for law and government in ensuring a fair and functional marketplace. This commitment to grounding legal arguments in observable reality rather than abstract pronouncements found its most potent and influential expression in a novel approach to legal advocacy that would forever alter the landscape of jurisprudence. The traditional legal brief, a document submitted to a court, often relied on precedent, logical deduction, and philosophical arguments. While these elements remained crucial, Brandeis perceived a critical deficit, a failure to adequately incorporate the tangible, empirical evidence of social and economic conditions that legislation aimed to address or regulate. This gap was particularly evident in cases concerning labor, public health, and consumer protection, where the human cost of particular practices or the societal benefit of regulatory measures were often articulated in broad, unquantified terms. The intellectual and practical challenge Brandeis confronted was how to persuade courts, steeped in established legal traditions, to acknowledge and act upon the complex realities of industrial society. The prevailing legal culture often favored established doctrines and resisted arguments that seemed to introduce extraneous, non-legal considerations. Brandeis recognized that to effect meaningful change, he needed to demonstrate the direct consequences of legal principles and policies on the lives of ordinary people, supported by verifiable data. His solution was to meticulously assemble a collection of sociological studies, economic statistics, and medical findings, presenting them as integral components of his legal arguments. This innovative strategy, which would come to be known as the Brandeis Brief, represented a profound departure from conventional legal practice. The seminal case that showcased this groundbreaking methodology was Muller versus Oregon, decided by the Supreme Court of the United States in 1908. The case involved an Oregon statute that limited the working hours of women in laundries to 10 hours per day. The employer, Kurt Muller, challenged the law, arguing that it violated the liberty of contract, a principle that protected an individual's freedom to enter into employment agreements without state interference. The prevailing legal precedent, particularly the Supreme Court's decision in Lochner versus New York, had established a strong presumption against such labor regulations, viewing them as undue infringements on individual economic freedom. Brandeis, representing the state of Oregon, faced the daunting task of persuading the court to uphold the statute. He understood that a purely theoretical legal argument, relying solely on precedent, would likely fail given the court's existing orientation. Instead, he meticulously compiled a brief that was unlike any submitted to the court before. It contained a mere 2 pages of traditional legal argument, referencing relevant statutes and previous cases. The overwhelming bulk of the brief, however, was dedicated to presenting a comprehensive array of factual evidence concerning the detrimental effects of long working hours on the health, safety, and welfare of women. This evidence included reports from physicians, factory inspectors, and other public health officials detailing the physical toll of extended labor. Brandeis presented statistics on industrial accidents, rates of disease, and the impact of fatigue on productivity and morality. He cited studies from Europe and America that demonstrated a correlation between long working hours and negative health outcomes, including increased rates of miscarriage, nervous disorders, and general physical exhaustion. The brief effectively argued that the state had a legitimate interest in protecting its female workforce, not as a matter of paternalism, but as a necessary measure to preserve public health and ensure the well-being of future generations. The impact of the Brandeis Brief on the court's decision was undeniable. While the court still referenced traditional legal arguments, the extensive factual data presented by Brandeis played a pivotal role in its reasoning. Justice David J. Brewer, writing for the majority, explicitly acknowledged the brief's contribution, stating that the court had examined the authorities there cited. The court ultimately upheld the Oregon statute, establishing a significant precedent that recognized the state's power to regulate working conditions for the protection of public health and welfare. This decision marked a crucial turning point in American labor law, validating the use of empirical evidence in legal arguments and signaling a willingness by the court to consider the social and economic realities of industrial life. The significance of the Brandeis Brief extends far beyond the specific outcome of Muller versus Oregon. It fundamentally transformed the practice of legal advocacy. Lawyers and legal scholars began to recognize the power of incorporating social science research, statistical analysis, and other forms of empirical data into their arguments. This approach allowed for more nuanced and persuasive presentation of legal issues, demonstrating the tangible consequences of legal decisions on society. It provided a framework for arguing that laws should be evaluated not only for their logical consistency or adherence to abstract principles, but also for their practical effectiveness and their impact on human well-being. The legacy of this innovation is profound and enduring. The Brandeis Brief paved the way for the broader acceptance of social science in legal proceedings, influencing fields ranging from constitutional law and civil rights to environmental regulation and antitrust enforcement. It provided a powerful tool for reformers and advocates seeking to challenge existing legal doctrines or to advocate for new legislation grounded in factual evidence. The practice of presenting extensive factual appendices and expert testimony, now commonplace in many legal arenas, owes a direct debt to Brandeis's pioneering work in Muller versus Oregon. His unique ability to synthesize complex data and present it compellingly within a legal framework demonstrated a forward-thinking understanding of how law and society interact, setting a standard for evidence-based legal reasoning that continues to shape legal discourse and practice to this day. His contribution was not merely in winning a single case, but in fundamentally reshaping the very method by which legal arguments could be constructed and adjudicated. Brandeis's appointment to the Supreme Court in 1916 marked a pivotal moment. ushering in an era where his deeply held convictions about economic fairness and individual liberty would find their most profound expression. The Senate confirmation process itself is a testament to his controversial yet widely recognized brilliance, a battleground where his progressive ideals clashed with entrenched conservative interests. Yet, once on the bench, Brandeis would become a formidable advocate for a jurisprudence that sought to balance societal progress with the protection of fundamental freedoms. The problems of this time on the court were immense and multifaceted. America was navigating the complexities of industrialization, grappling with the immense power of burgeoning corporations, and confronting the growing inequalities that accompanied rapid economic growth. Questions of federal versus state authority, the scope of regulatory power, and the very definition of individual rights in an increasingly interconnected and mechanized world demanded careful consideration. Brandeis, with his background as a people's lawyer, brought an unparalleled understanding of these societal forces to the judicial arena. He saw the law not as a static set of abstract principles, but as a dynamic instrument capable of shaping and responding to the evolving needs of society. His judicial philosophy was characterized by a profound respect for individual autonomy, a keen awareness of the potential for unchecked power to erode liberties, and an unwavering belief in the efficacy of competition and regulation to foster a more just economic order. He approached each case with a meticulous examination of the facts, often drawing upon the empirical methods he had championed earlier in his career. This commitment to understanding the real-world impact of legal decisions allowed him to articulate arguments that were both intellectually rigorous and deeply resonant with the lived experiences of ordinary Americans. One of Brandeis's most enduring contributions was his articulation of privacy as a fundamental right, a concept he famously advanced in his 1928 dissent in Olmsted versus United States. The case involved the government's use of wiretap telephone conversations as evidence obtained without a warrant. Brandeis, in a powerful display of foresight, argued that the Fourth Amendment's protection against unreasonable searches and seizures should extend to intangible intrusions into private communications. He envisioned a future where technological advancements could create new avenues for government surveillance, and he sought to establish a legal bulwark against such incursions. His dissent famously declared that the makers of our Constitution undertook to secure citizens in their right to be let alone, the right most valued by civilized men. This eloquent defense of privacy, though a minority view at the time, laid the groundwork for future Supreme Court decisions that would recognize and protect this essential liberty in an age of ever-increasing electronic surveillance. He recognized that privacy was not merely about physical space, but about the sanctity of one's thoughts and communications, a core element of personal freedom. Furthermore, Brandeis consistently championed the concept of liberty of contract not as an absolute freedom for employers to dictate terms, but as a freedom that required protection from coercive economic power. He argued that true liberty of contract could only exist when parties entered into agreements from positions of relative equality. His dissents often critiqued laws that appeared to grant unfettered power to corporations, arguing that such arrangements could stifle individual initiative and create economic dependencies that undermine genuine freedom. He believed that a healthy democracy required a broad distribution of economic power, and that excessive concentration in the hands of a few was inherently dangerous to the republic. His legal reasoning often called for robust antitrust enforcement and thoughtful regulation to ensure that markets remained competitive and that opportunities were accessible to all, rather than being monopolized by powerful entities. Brandeis's dissenting opinions often served as intellectual manifestos, articulating a vision of the law that was ahead of its time. He understood that the judiciary's role extended beyond resolving individual disputes. It also involved shaping the legal landscape for generations to come. His willingness to dissent, to articulate minority viewpoints that challenged the prevailing legal orthodoxies, was a testament to his intellectual courage and his deep commitment to the principles he espoused. These dissents, far from being mere academic exercises, became influential texts that informed legal scholarship and inspired subsequent generations of lawyers, judges, and reformers. The ideas he advanced in cases concerning labor rights, corporate accountability, and consumer protection eventually found their way into majority opinions and legislative reforms, demonstrating the profound impact of his judicial tenure. The legacy of Louis Brandeis is one of profound intellectual engagement and enduring practical impact. He was a lawyer who understood the power of evidence, a jurist who championed individual liberty, a reformer who believed in the capacity of law to create a more just and equitable society. His work on the Supreme Court, particularly his prescient defense of privacy and his critiques of concentrated economic power, continues to resonate in contemporary debates about civil liberties, data protection, and the regulation of large technology firms. He demonstrated that a deep understanding of social and economic realities was essential for sound legal reasoning, and that the law could and should be a tool for advancing human welfare. Brandeis's life and work offer a compelling model for public service, showcasing how a commitment to principle, combined with intellectual rigor and a profound empathy for the human condition, can indeed shape the course of justice and leave an indelible mark on the fabric of society. His vision of a society where economic opportunity and individual freedom flourished remains a vital aspiration, a testament to the lasting power of his legal and philosophical contributions.
We really appreciate you tuning in to this AI-powered presentation. Our goal is to push the boundaries of AI in content creation, and your input is invaluable. If there's a particular subject you'd like to see us tackle next, or if you have suggestions on how we could fine-tune our AI's creative prompts, please don't hesitate to leave your ideas in the comments section. We're excited to bring you more unique content very soon.